Hi Year 12, this video is a really quick review on grievance procedures. I'll be going through each stage and what they mean for a business. This diagram here is like a flow chart about how we move through each steps of the grievance procedures. Grievance procedures is the overarching name for all these steps together, and grievance procedures are a policy that a business will have in place so that employees understand how to air any problems or disagreements that they might have either with colleagues or with the employer themselves. It's in the interest of a business to have really clear and effective grievance procedures in place to make sure that workplace disputes don't get through to these really high levels of involvement of courts and tribunals, because that can be expensive, it can lead to negative reputations, and it can take time away from work as well. So it can end up being very costly to a business. So it's very much in both parties' favour to get any disagreements sorted early on in the process. The first step in grievance procedures is negotiation. Negotiation is exactly what it sounds like. It's two parties that are in conflict coming together to try and reach a conclusion with the other. There's no formal observations normally at this point, and it is just between the two parties that have a disagreement, be it employee-employee or employee-employer. Nothing decided at this stage, however, can be legally binding, so it isn't always effective, but it is definitely the first starting point because negotiation is a generally free process because it happens just between employees or employee-employer, and there's no involvement from Fair Work Australia at this point, so it can be kept in-house. The second stage of the grievance procedures is mediation. Mediation is very similar to negotiation, except at this point, a neutral third party is brought in to listen to the concerns of each party. So this could be a Fair Work Australia representative, or it could be somebody else neutral from within the business. But finding somebody else neutral from within the business can be a bit difficult to do because people always tend to have vested interests. So often a Fair Work Australia representative will come in. They will sit down with the parties that are in dispute, they will have discussions and try and reach an agreement. However, again, nothing decided at this stage is legally binding. So if the parties don't agree, then things will start to move into the involvement of courts and tribunals. Once we start to get to the involvement of courts and tribunals, things become a bit more serious. They start to cost money in terms of legal representation or advice from other bodies, and it also tends to take time away from work as well because these can't be done in-house and they will require the assistance of Fair Work Australia, potentially of lawyers, and finally the potential involvement of courts and judges. So this is when things can start to become really publicised and it can start to have negative costs for the business or for the employee. Mediation is the first step in this stage, and it is when a Fair Work Commissioner is appointed to the case to try and help the parties come to an agreement. They will work with both sides to try and make some sort of arrangement that suits the interest of both parties. However, nothing is still legally binding at this stage. So if a Fair Work Commissioner can't get the parties to come to an agreement, they will move through to the last step, which is arbitration. The final step, arbitration, is when the case will move to a court or a tribunal and be heard by a judge. Anything that is decided in this arbitration stage becomes legally binding. There is no further room for investigation or negotiation. Anything decided here sticks. So whoever is found in favour of gets to have what they have won, I guess, at this stage. It might be that a judge decides a pay rise has to be put into place or working conditions have to be changed, or a judge may find that there is no case to be answered and everyone is expected to go back to work. So anything decided here is legally binding. Once we get to this stage, as I said, it can be quite expensive because you're thinking about paying lawyers, etc. And it also becomes quite costly in terms of time taken to achieve this, because arbitration can take a long time. They can drag through the court system, and so it can prolong any conflict that is occurring, which then might impact some of those workplace indicators like corporate culture or worker satisfaction. It might lead to increased absenteeism or because people are not happy at work while a process like arbitration is going ahead, because there's that tension that still might exist in the workplace. So as I said at the start, it's really important that businesses have strong grievance procedures in place to try and encourage disputes to be dealt with kind of in these two phases. But if they can't be dealt with, then these courts and tribunals do exist to protect both employees and employers. If you have any other questions about this or any other topics you'd like a quick revision on, please don't hesitate to send me or Mr. Lobsey an email.